I'm going to first introduce Mr. Michael Cooper, who is the Deputy Shadow Critic for the Justice field, and he will then introduce our stakeholder, Sheri Arsenault.
Thank you, Tony. We're here to discuss Bill C-75, which is the Liberal government's legislation that is purportedly aimed at reducing the backlog in Canada's courts. For the last 2 weeks, the Justice Committee has held extended hearings on Bill C-75, hearing from a large number of witnesses. And based upon the overwhelming evidence before the committee, it confirms our worst suspicions that Bill C-75 is a train wreck. Rather than reducing delay, Bill C-75 will likely increase delay. It is a fatally flawed piece of legislation, and without more, the government needs to go back to the drawing board and start again. Not only will Bill C-75 not reduce delay, it will reduce sentences for some of the most serious crimes in the criminal code. We're talking about offenses such as impaired driving, causing bodily harm, terrorist-related offenses, arson-related offenses, and that's just scratching the surface. The government is watering down these sentences by hybridizing them. What that means is that offenses that are currently serious indictable offenses with a maximum sentence of up to 10 years behind bars will be prosecutable by way of summary conviction. The effect of that means that instead of a 10-year maximum, the maximum of prosecuted by way of summary conviction would be reduced to 2 years less a day and as little as a mere fine. In addition to watering down sentences under the guise of creating efficiencies, it's not going to create efficiencies. In fact, what it's going to do is download more cases onto the provincial courts that are already burdened. 99.6% of cases in Canada, criminal cases, are before provincial courts, so moving more cases down to provincial courts is not going to speed up the process. I would like to now turn it over to Sheri Arsenault. Sheri is someone who I've gotten to know since I was elected as a member of Parliament. Sheri is a mother. She lost her son, Bradley, who was 18 years old, at the hands of an impaired driver who was 3 times over the limit. Bradley and 2 other young men, Cole Novak and Fad Lake, lost their lives on a road south of Edmonton one evening. And since that day, Sheri has really been a tireless advocate for holding individuals who make the choice to drink and drive accountable for the seriousness of their crime. Unfortunately, far too often, the justice system has failed victims of impaired driving. The justice system has failed Sheri and her family. And if Bill C-75 passes, a whole lot more families are going to be let down and victimized because people who make that choice, who commit that serious crime, are going to continue to walk away with a slap on the wrist. Sheri.
The protection of society from the actions of criminals that commit serious crimes is one of the most important responsibilities of our government. Our members of Parliament, as representatives of all Canadians, are entrusted to develop good legislation and laws that will protect our children and our families. C-75 is not good legislation. It does not protect the general public, and it's a slap in the face to victims. As a mother, I find our government, instead of strengthening the criminal code by holding offenders accountable and responsible for serious offences, they are reducing the penalties by way of summary convictions at prosecutorial discretion. In 2011, my young son Bradley and his two good friends Cole and Thaddeus were killed by an impaired driver. By making serious offences such as impaired driving causing bodily harm into a hybrid offence, the message to all Canadians and victims is very loud and clear. Impaired driving is not considered serious, and in fact, it's not even considered dangerous. Lessening crimes will not speed up the court system. It will offer no sense of justice to victims, and it will offer no deterrence or even time for rehabilitation to offenders. Our justice system is going 10 steps backwards. The general public and victims are very concerned about the hybridization of offences, which will cause a downward creep in sentences, reduce deterrence, and increase serious crimes. Clearing up the backlog in our justice system should never be done at the expense of victims and public safety. Bill C-75 would have serious consequences, and the long-term damage would take decades to correct. To reduce these offences sends an unthinkable message to the public and to victims. I would like to remind our Justice Minister there is a victim behind every single crime, and our government needs to recognize serious crimes and leave them as indictable offences. Put public safety first and foremost. Thank you.
Thank you, Sheri. Let me just say a few words as well. First of all, thank Sheri for her courage and strength to come here today, and also to be at committee last night, to be a witness at the Justice Committee, and for advocating for the rights of victims after such a great personal loss that she and her family have suffered. It really is amazing that she has the will to do this, and we stand by her and other moms and dads and others in calling for significant amendments to Bill C-75, this omnibus justice bill. Along with Sheri and MPs Cooper and MacKenzie, and on behalf of the Conservative Caucus and our leader Andrew Scheer, I want to highlight some of the most egregious problems that are being identified by many witnesses, not just Sheri, many other witnesses who've come forward with their concerns over the Liberals' omnibus justice bill. These include legal experts, defense counsel, chiefs of police association, others trying to protect our nation against hate crimes and promotion of genocide. And I just want to re-emphasize that this is an omnibus bill. It's the same kind of bill the Liberals said they would never introduce or implement, but alas, here we are to discuss a 300-page long piece of legislation that is making monumental, and in many cases unfathomable, changes to the Canadian justice system. Hier, le Comité permanent de la justice a conclu des heures de témoignage sur le projet de loi C-75 et les membres du comité ont entendu que le projet de loi aura des implications plus profondes et plus durables qui nécessiteront des années et d'innombrables heures devant des tribunaux pour être réglés. Let's be clear that by and large, this is not a thoughtful approach to reform. It is mostly a reckless reaction, not well thought out, to the Jordan case that has legal experts and victims' rights advocates across Canada more than scratching their heads, calling on the Liberal government to abandon many of the proposed reforms. I just want to provide a snapshot to you of what the Liberals are proposing and what we find the most troubling. Most strikingly, the Liberals are watering down penalties for numerous crimes in Bill C-75. The long list of 136 offences that they're watering down include participation in activity of a terrorist group, leaving Canada to participate in activity of a terrorist group. Human trafficking is watered down. Municipal corruption, impaired driving causing bodily harm, which Sheri has talked about, blood alcohol level over the legal limit causing bodily harm, marriage under the age of 16 years of age, and even advocating genocide. All of those provisions are now hybrid offenses. That is to say, they water down the sentencing of these very egregious crimes. When you consider the gravity of some of these crimes, like drunk driving causing bodily harm, leaving Canada to join ISIS, and young girls being lured into sexual slavery, and the fact that these crimes could be reduced to fining offenses, it defies all logic and is absolutely outrageous. Nous avons aussi appris comment nombre des changements proposés dans le projet de loi C-75 freinera encore plus le système de justice pénale, dont les restrictions sévères aux audiences préliminaires qui, dans bien des cas, permettent d'éviter que des affaires soient jugées encore. Indeed, the Liberal approach to jury reform is also being challenged by numerous witnesses who testified that the abolition of peremptory challenges will actually make juries less diverse, not more diverse. Le comité a aussi combien le fait de rendre des infractions mixtes aura un impact négatif sur la soumission d'échantillons de ADN à la Banque nationale des données génétiques. La non-inclusion potentielle de la banque de données des infractions punissables par la mise en accusation aura des conséquences négatives sur les enquêtes de police partout au pays. Let me just say that again. The committee also heard how the hybridization of offenses will negatively impact the submission of DNA samples to the National DNA Data Bank. Removing indictable offenses from potential inclusion into the data bank will have a negative impact on police investigations across the country. To the many witnesses who took the time to come to Ottawa, and to all those who made submissions on the serious implications of Bill C-75, I tell you that the Conservative Party is listening. Conservatives will be proposing numerous amendments to this omnibus bill and look forward to working with the stakeholders to ensure that our justice system, which is in so many ways forms the backbone of our democracy, is not compromised by these Liberal revisions. Thank you, and we're here to take any of your questions.
Clement, today you're making this announcement with Ms. Arsenault. Yesterday you were talking about the Stafford case. For a few days you've been talking about this veteran son. Is there an electoral theme here being developed around soft on crime Liberals kind of thing?
No, I think that we're just seeing a course of conduct by this Liberal government, which is a pattern. And the pattern is forgetting about the rights of victims and their families, forgetting about the need for society to see true punishment when crimes are particularly heinous. And it seems that the Liberal government has forgotten this. They've forgotten what the people care about. They've forgotten what even many legal advocates have been caring about. They're not listening to anybody. And what we found at this committee, which was, I will say, surprising to me, I will say, I was surprised. The people that you would normally associate with perhaps the Liberal point of view were actually coming to committee and saying, this is not going to work. It's actually going to make matters worse. It's actually going to reduce the rights of victims and reduce even the rights of the accused. So to me, this shows, if it shows anything, it shows Liberals aren't listening, and Liberals are moving down a path that will make things easier for criminals to get away with crimes and harder for victims to see the justice that they deserve.
Why do you think that is? What do you think is going on?
I think they've lost touch. They've lost touch with Canadians, and the impact of that is starting to be felt by people.
So just so I can understand what you've said here, because I wasn't following the committee last night.
No,
this bill is a response to the Jordan
Correct.
judgment. So the goal, I guess, was for them to streamline the system, but you're saying it's watering everything down. But when you talk about the drinking and driving situation, I mean, isn't C-46 all about stopping people in a random way and people are drinking, and isn't that like stepping up the drinking and driving?
I'd like Sheri to talk specifically to that because she has that point of view of a victim and of course and her son. But let me say this: it was a response to the Jordan case, but what we heard from the testimony was even from likely allies this ain't going to work. It's actually going to make things tougher. When you have the defense bar coming forward and saying, yeah, we want to help our defense clients, but this ain't going to work, it shows you how far off track they are. And then, of course, we heard from victims' rights advocates. We heard from B'nai B'rith last night, who are worried about the watering down of the provisions about advocating genocide. We are supposed to be a leader in the world for human rights and contra genocide, and yet we're watering down the provisions here in Canada that relate to advocating genocide or participating in terrorist activities. This is going 180 degrees in the wrong direction. Sheri, come forward, talk a little bit about your point of view.
I could speak to your question about Bill C-46. In Bill C-46, which was touted as the toughest piece of legislation ever on impaired driving, there's nothing in there. They removed anything significant, and what they put in was random breath testing, and they increased dangerous driving from 10 years to 14 years. Those are the only two things they put in there to make it a little bit tougher. And in Bill C-75, they take impaired driving causing bodily harm and they hybridize it to possibly only a mere fine. So they're telling me that impaired driving is not only not serious, it doesn't even rank up there with dangerous. That's all that happened in Bill C-46 regarding impaired driving. They didn't strengthen it, they didn't toughen it up, they did nothing at all for the victims in that bill.
Mr. Cooper, if I can ask you about
Thank you.
hybridizing, I'm sorry, I have a hard time with that word.
Yes. Reclassification.
Let's call it that way. The government says, yes, we are changing, but we're changing the threshold from 2 years minus 1 day to 5 years in some cases. And also it leaves some discretion for the prosecutors to either go one way or the other. So can we not assume that in the most egregious case, the prosecutors would still go for the toughest penalties?
There are many offenses that have been part of this list of 130-some offenses that have no business being there. When we're talking about inciting genocide, when we're talking about impaired driving causing bodily harm, or an array of terrorist offenses, these are serious offenses. And if you take the logic of the minister, which is to say all it is about leaving discretion to prosecutors, then it really begs the question, why do we have indictable offenses at all? Well, the reason we have indictable offenses is because there are certain offenses that are serious and need to be treated as such, with 10-year maximum sentences. Now, just with respect to Bill C-46, Sheri has been very, very vocal on that issue, but their approach, the Liberal government's approach on Bill C-46, was much the same as their approach on Bill C-75, which is to be hard on victims and soft on criminals. The Liberals, yes, they increased the penalty for impaired driving causing bodily harm from 10 years to 14 years, but what Sheri said when she came to the Justice Committee was, big deal. What does it mean? Because no one ever gets 14 years, no one gets 10 years. Most cases, they get a slap on the wrist.
And therefore my question,
Yeah.
so if nobody gets 10 years,
Yeah.
what does it change that now the threshold is 5 years if in fact nobody gets 10 years anyway?
We pushed forward with mandatory sentences for the most serious of impaired driving offenses, which is what the previous Conservative government introduced in Bill C-73. The Liberals shot it down.
And we had, I also want to answer that a little bit and say certainly the testimony we heard from the witnesses was that by creating these summary convictions, by watering down the sentencing, you're sending a signal to the system that these offenses are not being taken as seriously by the state as they were prior to Bill C-75. So we heard a lot of witnesses say they're worried about the signal it sends, and that this will be replicated through the system.
So can I ask you then, if the whole goal is to streamline the system to respond to Jordan, obviously you have concerns about how they did it, but you do have to respond to Jordan. So
So we will be proposing amendments. We heard a lot of testimony. The testimony was very high quality. I'm sorry, I know it's busy around here, but I do recommend that you take a look at some of the testimony, because they not only criticized the bill, but they came up with very straightforward, common sense suggestions that could help streamline Jordan without affecting citizens' rights. So those will be, you will see soon enough that the Conservative caucus has heeded some of that advice, and we will be proposing amendments that we think will make the bill better.
On a different subject about healing lodges, there's been a lot of debate over the last 24 hours about healing lodges in general across Canada, and specifically considering that McClintic is a sexual offender and now she's in an institution where there are children present. Does this cause maybe concern, or do you think it's time to review healing lodges? There's also a number of reports that reoffending rates are high, people escape them in general. What do you think about the lodges and the fact that sexual offenders are in them when there's children present?
So this afternoon, before the Public Safety Committee, the head of Corrections Canada will be there. I will be there too. I'll be asking some very important questions about what happened and why, and what are better solutions to this. Our concern yesterday is, again, for the victims who have been re-victimized by this situation, and by society which is offended by this situation. And our point of view is it was transferring her to that kind of environment, the child murderer, to that kind of environment, is offensive from a justice point of view. It's offensive from a public point of view. It's offensive from sending the right signal point of view. All of these things, it is offensive to Canadians.
I was talking with a specialist yesterday who studied the prison system, and this person was telling me, well, this is not the first time that someone who's done something very serious is being sent to those healing lodge. There are other murderers there, people who've done very horrendous crimes. So I repeat the question to my colleague: should we question the very existence of those lodges?
I think they do provide a role in our criminal justice system. So I'm not here to question the existence of healing lodges, because I think in certain cases they can be helpful, and they can reduce recidivism, and therefore they can be part of our justice system. But clearly, it is being used in ways that is not helpful to justice, and is not helpful to protecting the public and for public safety. So that's where Conservatives say this is wrong. If it's happened in other cases, those cases, those are other cases which show that there have to be rules about the applicability. And so this will all come out in the wash, I believe. But to us, the big issue over the last 48 hours has been child murderer who reoffended while in prison, by the way, let's not forget, reoffended while in prison, transferred first to a medium security, that might be appropriate, but then from there, from Kitchener to Saskatchewan, completely inappropriate, completely offensive and outrageous.
Is it your understanding then that Ralph Goodale can actually reverse this?
Well, I was a minister once, and I can tell you that if the minister and prime minister feel strongly enough about something, it's amazing how the wheels can turn. And I believe that they do have tools available to them to review this situation. And they should have stood up in Parliament yesterday, not just to say we're reviewing generally the situation. They should say we have put a stop to the situation and we're reviewing the situation. And they did not do that.
But isn't Corrections Canada supposed to be independent of the political system?
Corrections Canada ultimately reports to a minister, Julie. And this is our point. This is why we elect people. If people can make these kinds of decisions without being accountable for them, then we have a very big problem in our democracy, and the Liberals are contributing to it.
But won't you be asking the head of Corrections Canada then, who obviously has an ability to do something, to send her back?
Well, these are the questions I'll be asking in a few short hours, and I'm looking forward to getting his point of view on this. But it has highlighted for Canadians just how this Liberal government is so nonchalant about victims' rights and about protection of society, and that's the point we were trying to make yesterday.
To return to the point I was making, that this is not the first horrendous criminal being in these lodges. And people are talking about politicization of the whole process. Don't you think that maybe the better way of doing this would be to review the entire rules around under what criteria you should transfer this?
And that should be done, and absolutely you're right. But we also feel very strongly that McClintic should not be there. She should be behind bars. She should not be in a place where children are at. She should not have the amenities available to her that she has. And so that's our point too. Your point, well taken. But we also have a point to make about the particular case.
Yesterday, the Prime Minister urged you to stop getting into graphic detail. And I'm wondering, when you were talking about people being re-victimized by this, I'm just asking.
Sure.
Were you concerned that by reading out all the graphic details that you could have maybe been re-victimizing people?
Look, we made a judgment call, which I agree with, which all of these details were in the media over the last 48 hours. They were available. And why were they in the media? They were in the media because it was relevant to understand why this was an egregious, totally unacceptable situation. So we make no apologies for, in the House of Commons, using our freedom of expression to put the context around the issue. I think we did so in a respectful way. And if you review the tape of my questions, I was respectful to the Prime Minister. I did not fly off the handle. I didn't shake my fist at him or light my hair on fire. I was there to be respectful, but to ask the question, which we are elected to do on behalf of the victims in that case, but also more broadly on behalf of Canadians. And we're content that we did that. Thank you very much.
You should have let